Hi, it's Councilmember Jason Lyon, Pasadena District 7, back with another edition of Pasadena in Perspective, our occasional series of videos examining how changes in federal policy impact our city. This time we're looking at federal immigration enforcement. In March 2017, the Pasadena City Council adopted Resolution 9557, declaring that city resources, including the Pasadena Police Department, could not be used to assist in federal immigration enforcement. This is an especially salient issue for Pasadena because at any given time, our population is about 30% foreign-born, and still more of our residents are the American-born children of immigrants. One rationale cited by the City Council at the time of the resolution's adoption was the public safety importance of ensuring that victims and witnesses of crimes feel safe to come forward and tell their stories to police, regardless of immigration status. So that's been the city's policy for the past 8 years. On January 21st, however, the United States Department of Justice issued an internal memorandum instructing U.S. attorneys to investigate and prosecute local actors who resist, obstruct, or otherwise fail to comply with, quote, immigration-related commands, end quote, from the federal government. The term local actors is not defined, so in our case, it could mean the police chief, the city manager, the city council, or all of the above. And while I'm not aware of any reports yet of attempts to prosecute local officials for declining to assist with immigration enforcement activities, the DOJ has brought civil lawsuits against 2 jurisdictions, in New York and Chicago, for failure to cooperate. People of good faith and conscience can disagree about what American immigration policy is and what it should be, given the role that foreign-born labor plays in the U.S. economy. But the enforcement issue brings some particular complexities, especially in light of another policy directive issued out of Washington in the same week as the DOJ memo. On January 20th, the president signed an executive order that purported to deny American citizenship to persons born in the United States to non-citizen parents. The problem with that order is that the 14th Amendment to the United States Constitution provides, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside, end quote. Article 5 of the Constitution provides that it can only be amended by the affirmative vote of 3/4 of the states after 2/3 of both houses of Congress or 2/3 of the states propose an amendment. In other words, the Constitution cannot be changed by executive order. And so far, there hasn't been a proposal through the constitutional process to amend the citizenship rule. As it stands now, at least 4 federal courts have issued injunctions on the implementation of the executive order redefining citizenship. However, the vice president issued a statement last week suggesting that the White House may be prepared to ignore those court orders. And that's where the problem comes up with regard to local enforcement. Even if Resolution 9557 were to be rescinded, which, to be clear, has not been proposed, every member of the Pasadena City Council took an oath to uphold the United States Constitution. The council could not both honor that oath and participate in an immigration regime that would have the effect of removing American citizens from this country. For now, all we can do is wait to see how the administration's policies play out. Whether the courts permit the executive order to stand, whether the administration abides by whatever the courts decide, and whether, in any event, the federal government attempts to commandeer our local law enforcement to carry out its policies. In the meantime, our policy remains the same. Unless and until it changes, the city does not have a role in immigration enforcement. As always, if you have any questions, you can reach me at jlyon@cityofpasadena.net.